We come to the time when it's on. We're discussing data and security. It's been mentioned time and time again during the sessions over the 2 days, but this is the session you may have been waiting for. It's completely dedicated to cybersecurity, data, and GDPR, and some other little surprises maybe. We have great discussion partners in Kristin from Nordic API Gateway, Emma from Sherman & Sterling, and Peter from Trifork. So I will hand over to you, Emma, and hope you would like to start. I think, are you muted, Emma?
Good morning.
Thank you.
I'm fine. Good morning, good afternoon, wherever you might be. This is a very early good morning from the heart of Silicon Valley. I'm Emma McConnick. I am a partner at the law firm Sherman & Sterling. We are a global law firm with offices pretty much everywhere. And I am in the IP transactions team, and I help lead the data privacy and cybersecurity team here. And as you can probably imagine from the fact that I'm in the heart of Silicon Valley, we deal with a lot of really interesting and novel data privacy and cybersecurity issues. I'm also based in California, which is probably pretty progressive with respect to the way that we perceive data privacy and cybersecurity law. And a lot of our clients are global, so we're looking at data privacy and cybersecurity products and regimes all over the world. So that's a little bit of what we're going to talk about for today, sort of divergent and potentially convergent views between what's happening in Europe and what's happening in the United States. I'm going to hand over to my fellow panelists to introduce themselves, and then I think we'll kick off after that. Peter, would you like to go next?
Sure. So my name is Peter Flintholm. I work as a developer lead and technical product manager at Trifork. My background is a little bit different than Emma. My background is security, cryptography, software development. So I primarily work in identity management solutions and all the related security protocols and subjects around that area. In Trifork, we have dealt with a lot of different bank projects, fintech startups, and mostly a lot of work within the health sector. So a lot of different, very sensitive data. Yeah, Christian?
Yeah, my name is Christian Penton. I'm the co-founder and DPO for Nordic API Gateway. We serve PSD2 services for like open banking services for large international banks, and we also do it for a variety of fintech institutions. And we also hold our own TPP licenses, which means that we also am the controller of many different types of data in the financial sphere. Yeah, back to you, Emma.
Thank you so much for that introduction. So for those of you that are joining us, I think one of the issues that we come across, and particularly in the financial institutions sector, is sort of how to manage different approaches to data privacy and cybersecurity and increased proliferation of rules, regulations, regimes that are intended to provide greater transparency and greater access, but maybe operationalizing those rules doesn't actually realize that greater transparency and greater access. As you have all lived through the implementation of the GDPR and how that has changed the way that you are accessing, processing, using, and storing data, we over in the United States are also experiencing a similar change and a similar approach to how that happens. And I think there is a perception that Europe and the United States have very divergent views towards privacy, data protection, and cybersecurity. And I think I expect that by the time you leave this panel, you may leave with a different perspective on that, certainly based on what we're seeing here. And I think part of the challenge that any entrant into this market has is how to navigate these spaces, how to ensure that you've got your security to the levels that you need to get the amount of trust, the right levels of trust from your consumers, including in the institutional banking sectors, which we deal with a lot. You know, our firm is headquartered in New York. We've got a significant presence in London, so we're dealing with financial institutions fairly frequently, and the inevitable security challenges that increasing online presence and digital applications and access to data is going to cause increased processing, increased use of AI systems, increased use of disruptive, novel, really interesting fintech technologies. How do you operationalize and implement all of that? It's complicated, and there is no silver bullet, unfortunately. You just have to sort of knuckle down and work your way through the process. And I wanted to first sort of start in Europe, since you guys are all based in Europe, and maybe talk a little bit about PSD2. And I thought I would send this question over to you, Christian. We're going to try and do this a little bit as a dialogue to try and make it a bit more interesting for you guys. And I just wanted to get a sense from you, Christian, about what you think the role of the regulators has been with respect to the implementation of GDPR and PSD2 and the increased focus on data protection. Do you think this has led to any kind of conflict of interest, or what kind of challenges do you think it's posed for European fintechs?
Yeah, you could definitely say in sort of this era that things are, and it's an interesting period of time we're living in right now when it comes to trying to figure out like who wants to own the regulatory side of everything that has to do with fintech data. Right now we see that we have two major players. We have the national data protection agencies that play a role, and we have the national competent financial authorities trying to play a role in this sphere. And you can see that since PSD2 was sort of born sort of in the cradle together with GDPR being implemented, you see that a lot of the ideas are kind of transferring between the two sets of regulations. And now you're sort of seeing this battle playing out after the fact of where we actually heading with all this regulation. So a very interesting thing is, at least from the PSD2 side, is that it actually comes in a lot when it comes to opening up banking data for third parties or fintechs. It comes up as a like a competition enforcing methodology that you're trying to make the banks open up the data, not trying to keep out competition from the banks themselves. And therefore, the agenda on that is opening up as much as possible, basically. And then on the other hand, you have the data protection agency coming in from the other side and saying, well, you have to protect everybody, right? And you actually see this playing out at this moment, because you see the European Data Protection Board, they actually have a hearing out this, which is due today, on this exact matter, where we kind of have the difference between whatever is going on within the PSD2 legislation and national legislation when it comes to that, and when it comes into the GDPR itself. And you definitely see it in many cases. And I would just like highlight one example. I guess a lot of banks, especially some of the early movers in the PSD2 sphere, they saw themselves as sort of a gatekeeper. They wanted to, mock like a consent dialogue, for instance. They wanted, to be really elaborate, like you would share information from Google or Facebook. They want to be elaborate on what information actually gets shared and how it gets shared and stuff like that. But in the world of the PSD2, that can actually be seen as an obstacle, because you can kind of put dissuasive language in there saying like, are you really sure you want to do this? And therefore it kind of can head into countering this sort of openness agenda and the sort of competition agenda, where you don't want to dissuade anybody from participating. Right.
Yeah, I mean, I think, that's an ongoing challenge, is having to sort of walk this tightrope between access and trust, essentially, trying to provide people with access to all of these different systems, but making sure that it's done in a secure manner and it's consistent with, all of the different laws. One of the challenges that we have in the United States is that there is you can't talk about privacy or data security in the United States without talking about the patchwork of regulations. And I'm seeing an increased fragmentation on some level in Europe, where the GDPR, is explicitly designed to be the grand harmonizer legislation, but in fact, there are other industry-specific rules that are starting to apply. And in particular, in the open banking sector, I think it would be good for us to sort of understand a little bit about what the role of open banking has been with respect to some of these data privacy issues in the EU. How do you see that playing out, Christian?
I might put an emphasis on that GDPR is like two things, right? It is about protecting data, but it is also about access to data, that you can sort of put your data into play, that you can use your data for good, actually, not only see data as something that is like vicious and you shouldn't share it with anybody, but you can actually use your data for something good. And if somebody have data about it, it's about porting that data into the purposes that you actually want to use it for. So what I see open banking about is actually an extension of that culture, that you want to use data for the good, and it's something that you are in control of. And I think that actually that is some of the success parts of open banking, despite sort of all these differences between, or in opinion, on who should actually ask for what permission and sort of the granularity of everything here. But the success is that we're starting to use financial data. And I think that is the most important part. And I think the GDPR plays a huge role in that, because if it wasn't for the financial regulators, then GDPR could have been pushing this agenda as well, with data portability, with data subject rights and other things, that where you could start sort of imposing upon financial institutions to start giving away data to users that actually want to use it in other systems.
Yeah, it's a complicated issue, because I think data should be free, like speech, not beer, and to try to make it accessible to people who want to use it for good purposes. It's certainly something that at least the American psyche here struggles with on some level. There's a real disconnect between how consumers perceive the use of data for, sort of consumer-led applications or data-driven decisions in the advertising sector, relative to how they perceive the use of their data for good purposes, in particular in healthcare, or if you're trying to, sort of contribute your data for clinical trial purposes or something like that. Although the nature of the data is significantly more sensitive, there seems to be an openness to doing that in America in a way that, personally, as a practitioner who has, I trained and worked in London and in Europe for years, and then moved over here, it's kind of a surprising dichotomy. But I think at the heart of all of what we're talking about is providing the natural persons, the data subjects, the individuals, those terms are different across multiple jurisdictions, with a real sense of security and ensuring that at a technical level, you are complying with these regulations and that you are doing what is required from a technical perspective. And I thought, Peter, it'd be really good to get your perspective on this and try to understand, what's involved in getting your technical stack in order to comply with these obligations early on, so that you are in a position to scale. That's one of the biggest challenges that a lot of our constituents have.
Yeah, so I think I'd like to address that topic by giving a few rules of thumb for the development process, rather than maybe talking about specific technical solutions. So I think first and foremost, you need to make sure your entire team and the processes are in what I would call a privacy by design state of mind. Mm-hmm. That's a very much used word and sometimes a little bit diffuse. But with that, I mean, for example, that the whole team should be aware of, never to collect, log, store, or otherwise process data you don't absolutely need for doing a certain task. Often it's like in the backbone of developers to, we can get this data and we can store this and maybe we can use this for later. That should be flipped around, basically. Also document all kinds of data you will be processing and make sure that everybody is aware that any kind of processing needs explicit consent for that particular type of data. Make sure that processing, whenever you do processing, you always verify that a valid consent is in place at that time. So that also means, for example, if you do batch processing and stuff like that, is the consent from the given user still in place? So processing doesn't always happen, on a direct user initiative. And often the idea of what actually constitutes person identifiable information can be a little bit abstract or far-fetched from a developer perspective. So I would recommend that you make a very clear definition of that within the team from the start. That will be, of course, domain specific. And finally, I think you should, from the start, build infrastructure to handle these consents from the beginning. Consent should be considered structured data that is explicitly represented in some appropriate system. It's not just implicitly given because the user once pressed OK button when they first used the app or the website. It needs to be tracked. It needs to be verified at all times. And the system you built for that should, for example, be able to store the consent text that has been shown to the user, versions thereof, date of consent, and so forth. And of course, have methods to revoke the consent, both on explicit request from the user, but also maybe given a limited lifetime of the consent. Yeah, I think that would be the very short list of things to have in mind from a technical perspective during the development process. One final subject I would like to have at the back head of everybody's head would be aware of the kind of cryptography you use, especially if you're starting out from scratch. There's this buzzword about post-quantum cryptography. It is a bit of a buzzword, but it is worth investigating. If you are going to start up and doing a lot of implementation right now, you might very well look into doing it future-proof from the beginning, which would mean doing it post-quantum hardened. But that's the subject of a whole nother talk.
Yeah, I feel like that's the kind of conversation we could and should have offline.
Yeah.
So there's plenty for us to cover in that space. And, look, there's certainly a lot happening. And I think a lot happening in that, and certainly in the security cryptography space. Some of that is driven by regulation. A lot of the liability that attaches in all these regimes that we've been talking about when you're operationalizing it, it's all about whether or not there was unauthorized access to data. And then as you drill through that definition, it boils down to, on some level, was that data encrypted? Was it, human readable, et cetera? So there are some fairly not straightforward. The solutions are straightforward. Sometimes the implementation can be quite a challenge. But we are starting to sort of see a unification of approaches to trust and to security and privacy by design, and I expect it's a surprise to many in the European audience, but they're absolutely not just buzzwords, they're sort of day-to-day words out here in Silicon Valley, and certainly increasingly in the United States. Certainly those companies that are technology and data intensive certainly have those technical prerequisites. And I think, one other follow-up question for you, Peter, was really sort of from a company perspective. I wanted to get a sense from you as to what other technical prerequisites you might have to getting access to good financial data, right? What are the challenges that you're going to need to have in play? What are that you're going to need to overcome to get really good quality data?
I'm not quite sure I have much to add to the conversation on that subject, honestly. That is more financial PSD2 information. I think maybe Christian.
Yeah, what are your thoughts, Christian?
Yeah, I think that first of all, like we need to, of course, to have a, as you mentioned yourself, like a proper basic quality, but you also need to like be comfortable in working in the environment that you are starting to consume this new data and you're starting to consume it in this new regulatory regime. And I think that some of the fintechs can actually be a bit luckier here than sort of established banks and established institutions, because you're actually moving into a sphere where since you're building everything from scratch in sort of a new environment, then you can actually start to tailor these things into the solutions upfront. And this is something that, at least from our perspective, we have had tremendous success, producing products this way, because we were able to produce them in an era where GDPR was baked in and we didn't have to bolt it on afterwards. And I think that sort of approach to regulation and how you build stuff is something that I think the financial sector, especially the fintechs themselves that are starting up, they really have a chance to thrive here. But actually, Emma, I want to go back to you as well, and we've been discussing a lot about the European perspective here, and I'm extremely curious. We had some chats before as well, but I'm curious to hear a bit more about, like, I have sort of this feeling that Facebook and Google, they just want to steal my data, and I have a feeling that the US is kind of behind on regulation here, because we have Mother Europe doing GDPR for us and making sure that we are doing everything by the book. But how is it actually looking, and what are the movements in the US at the moment?
It's a good question. Proving yet again the delta between perception and reality. And look, I get it. I've practiced in Europe for a long time. I have, my family's European, so I completely understand the perspective. And if you sort of zoom out to the 100,000 foot level, the European perspective and the United States perspective with respect to data privacy has different origins. And I think in Europe, we protect privacy as a fundamental human right in a way that hasn't, at least on the outside, been the perception in the United States. We have a different history about racial profiling or profiling based on certain characteristics of the individual. That said, I think it is a misnomer to assume that there is little to no protection of privacy in the United States. I think if you sort of, it's not by coincidence that those of us who remember the advent of the internet will also remember that that's when a lot of the regulations around how sectors in the United States use certain sensitive information. So, if you're looking at it from a jurisprudential perspective, the United States has always taken an exceptions-based approach to the regulation of privacy and sort of said, okay, are you dealing with some category of sensitive information? Are we talking about healthcare? Are we talking about financial institutions? Are we talking about kids? Certain classes or education, for example, certain classes of data that have a particularly sensitive aura attached to them in some way. And if they are sensitive, then we're going to regulate them, right? We've got the Gramm-Leach-Bliley Act in the financial institutions. You've got HIPAA in healthcare. You've got COPA for kids, and a proliferation of that's at the federal level, and then their functional equivalents at the state level. So there has, for a long time, certainly since the late 90s, been a regulation. Oh, I'm getting in it. Can you guys hear that?
I think we are running out of time.
Yeah, you are. Emma, would you like to finish? Is it still an echo, or would you like to finish your sentence?
I'll finish super quickly and say America is very privacy forward now. The biggest and the best companies that I work with see privacy as a competitive advantage.
Fantastic. We run out of time, so I'm sure we all are. I think many of my questions were actually answered by you, so that was fantastic. Thank you so much for joining. We're really, really happy to have you here. You're all experts within this field, and we're just super glad that you joined us. So thank you.
Thank you.
Thank you.
Bye.
Bye.